Good afternoon. I'm Bob Clifford, and as most of you know, and along with you, we're all interested in advancing our practice and our profession throughout the state of Illinois and elsewhere, and to promote civility and goodwill among all the lawyers and the profession. I hope that you find this program to be very timely. It's the changing ethical landscape of litigation, and it's another step in that direction I think you'll see from the hypotheticals and the materials review today. For the next 2 hours, our esteemed panel will take you through these hypotheticals, analysis, and study that will provide you with practical advice about how to better handle these issues. With thousands of lawyers across the state who have registered for this program, it's in what I think is the largest internet program in the nation. Title, Fighting Fair Ethics for Litigation. I'll tell you about that in a moment. I needed that name. Okay. We have one thing that's new this year. There's going to be voting. You're going to see on the screen in a moment, and the folks at home and at their computers will be able to vote along with the professors in deciding what the proper answer is. So let me just provide you, though, a brief summary of our panelists. You know, their full bios are in the materials that are in the handout and online. We have the Honorable Deborah Dooling, who was on the bench here in the Circuit Court of Cook County for, I don't want to say how long here, you'll get mad at me, but a very long and distinguished career. And she's taken a year off to find herself. And so it's a great thing. She's reprising her role, though, as a judge for our purposes today. And with her in a reprised role is Professor Robert Burns, an ethics professor at Northwestern University School of Law. And then next to Professor Burns, we have Jayne Reardon, who's the Executive Director of the Illinois Commission on Professionalism, and also joining us once again is the interactive feature of this program, and I'll serve as the moderator, and thanks for all of you being here today. To learn more about this topic, please explore the various materials and handouts that are available electronically or here in the room. The seminar is being recorded, and the 2-hour program on the materials will be available for viewing later at cliffordlaw.com. I must also make a special shout out to Professor Lawrence Fox from Yale. Special thanks to Larry, who graciously prepared the hypotheticals that we'll be talking about today, and he's been available to me and the panelists in preparation for this program. And the hypotheticals are a portion of the materials that are coming out in his new ABA book, Fighting Fair Legal Ethics for Litigators, soon to be distributed by the American Bar Association. And then finally, a shout out to my staff. We have Rachel and Ashley and Kevin Sowizro out there, and Sonia, and my law partner, Pam Menaker, each of whom this would not happen if it wasn't for their considerable and extraordinary efforts. So, panel, let me read the first hypothetical. It's called the beauty contest, and all of you here have this. You receive a call to defend a major accounting firm in a 10b5 class action involving a .com company whose stock has precipitously dropped. The accounting firm sent you the pleadings, and you met with them for 3 hours yesterday, explaining your firm's approach and the possible lines of defense that the accounting firm might use. The accounting firm promised to get back to you next week. Today, though, your partner circulated a conflicts memo asking whether the firm could take on the representation of the defendant underwriter in the same manner. What do you advise? Vote now while you're online, but what do you advise? We have no. Your meeting with the accounting firm means you have a per se conflict with the underwriter employee of the firm. Yes, the firm could represent the defendant underwriter because no attorney-client privilege was formed with the accounting firm yet. Or no, even though not retained, the firm received the pleadings and confidential information in the 3-hour meeting that could be significantly harmful to the underwriter. Professor Burns, what do you say?
Well, this implicates what for us old guys is a new rule, which is Rule 1.18. It addresses prospective clients. Used to be that people in this situation, accounting firm was treated as a former client. Used to be that someone in this position was treated as a former client under Rule 1.9, but now there's a rule that's specially designed to address this situation of prospective clients. And the first question is the accounting firm a prospective client within the meaning of 1.18? And I think the answer to that is yes. So the rule says that if you discuss the possibility of forming a client-lawyer relationship, they always say client-lawyer, main guy in the relationship. So if you discuss the client-lawyer relationship, then a possibility of it, then you're a prospective client. There's a new comment to this rule that basically says not everyone who you might talk to is a prospective client. So if you have a website, someone sends you his life story, but you haven't acknowledged the likelihood of representing that individual, not a prospective client. And the rule sort of self-protectively says, the comment says, if the only reason the person is talking with you is to disqualify you, and so you're not really in good faith about hiring you, then that person is not a prospective client either. So this person, the accounting firm, looks to be a prospective client. So the first question would be there. The general rule would be you can't use information you've gathered against the prospective client. You can't reveal prospective client information. It's like the ordinary rule of confidentiality in that situation. And the lawyer himself can't represent another individual adverse to the interest of that prospective client if he has gained information that could be significantly harmful. So it's a higher standard than the usual 1.9 standard, that it's a matter relating to the representation or substantially related. So you've got to have learned something that could be harmful to the prospective client in the meeting. That would preclude you from representing someone adverse to the interest. I assume here that the defendant underwriter could be adverse to the accounting firm in the representation, probably as co-defendants, I assume.
Well, let's see what Jayne has to say first, and then I want to talk about the poll. Jayne?
No, I agree with the professor, and the question that I had is it likely that he would have received information that would be adverse to the underwriter, and could there be, under any circumstances, a per se conflict?
Well, but think about this, though, and the thing that I don't understand about the poll, because the poll's coming out with the C. So you have two correct answers, both being no, but for different reasons. I mean, I've always practiced on the notion that once you sit down, you have that discussion. You've created, whether you have a contract, whether you've been paid $1, you've got an attorney-client relationship there. That's done. So wouldn't that bode towards answer number A? Has this rule changed that somehow?
Yes.
Professor? It has.
Yeah. If you sit down with someone and don't get any money, that initial conversation, for some purposes, you do have a lawyer-client relationship for confidentiality, for example. But this new rule basically changes the standard somewhat for someone with whom you discuss the possibility, as this rule thinks of it, forming a lawyer-client relationship, but then one or other of you decides not to go forward.
So are we saying that you need to peel the onion back a little bit more and that this becomes more issue-specific because of this new rule?
Yeah, that's right. I mean, the question is always adverse representation to the prospective client. And so, again, the standard is higher. If you haven't learned anything that's significantly harmful in the initial conversation, then there is no preclusion of the relationship. Two other important things in the rule, though. There's a screening provision. So the interviewing lawyer can be screened out of the case such that other lawyers in the firm might act adversely if the initial meeting was limited to the length, and here you have a 3-hour meeting, so not so clear, limited to the length to determine not just whether there's a conflict, but whether or not the lawyer wants to take the case. So there's a screening rule, and the interviewer could be screened off, and you could still do adverse representation, so long as, and this is a very loose standard, so long as the lawyer doing the initial interview limited it to the amount of time he or she needed to decide whether or not to proceed with the actual representation.
Jane, last word on this one. Anything further?
Nothing further.
Okay.
I just think you should tell the
Yes, the
people
results.
Yeah, so the results on the screen, we have 77% voted number C, the no, the right no, I guess, and the 20% voted A, no, the wrong no, and 3% are hiding in B somewhere, and that must be some senior members of the bar who thought that there wasn't any conflict that ever really mattered. I don't know. I'm just saying that, but you never know.
There's one other thing that's important here. Many law firms here in Chicago will attempt to get a prospective waiver
But we're going to come to that later. Okay.
this situation.
In this situation.
We have some questions, and I just want to point out at the top of the screen, when you see the question, that people here, even in the room, can use their cell phones to vote by text. So if you have a computer and you're out there, you can minimize your screen, and if you go to pollev.com/Clifford Law, that's how you vote. Or vote separately if you want from your cell phone. And you text to Clifford Law 22333, that allows you to join, and then you can vote. So I hope you can follow those instructions for those of you who want to participate in this voting.
And thanks for the idea for this polling from Jayne Reardon. She's observed this being used, and she's using it in her own work. She'll tell you about in a little while. And it's nice. It's more interactive. People are having a good time. Hi, Hugh. Good to see you, sir. Okay, hypo number 2. A match made in heaven. Savvy Sally decided she needed a quick divorce. Is there such a thing, Miles? And did much of the research and drafting herself. She wanted some limited expert advice and accessed the website of an online attorney matching service, Bravo. From Bravo's website, Sally selected the advertised legal service and chose Lawyer Larry as her preferred attorney. Sally pays the full amount of the advertised legal fee to Bravo. Thereafter, Bravo notified Larry of this action, and Larry called Sally within a specified period of time as directed by Bravo. After speaking to Sally and performing a conflicts check, Larry accepted the representation. After completing the divorce, Larry advised Bravo. Bravo sent Larry his legal fee, which was the amount Sally had previously paid Bravo, minus, and here's the issue, minus a marketing fee. Question, has Larry committed any ethical violations? Yes. Larry is impermissibly sharing legal fees with a non-lawyer? Yes. For other reasons in addition to impermissible fee sharing, splitting? Or C, no. Jane, what do you think about that? That's an issue that's come up a lot, hasn't it?
Yeah, Bravo might be familiar to you. This is a very hot topic in ethics circles right now. And in your materials are several state ethics boards who have considered Bravo's alter ego, AVO. And there's a whole host of very interesting ethical issues here. Sharing fees with non-lawyer is Rule 5.4, and some of the ethical rules or opinions have found that AVO's system involves that. It's really important to understand the system, which is a little opaque, to say the least. But when Sally clicks on something here, she could either select an option that a lawyer will call her back for a set price determined by Bravo, or she could click on something else which says, tell the lawyers in my area who practice in this area I'm interested. And so there is some selection piece there. When the lawyer answers and does the work, they're not paid until the end of the month. And then Bravo gives all the fees to the lawyer minus the marketing fees. The marketing fees vary by the cost of the matter. It's not a direct percentage, but there is a variance. So we have fee sharing with non-lawyers who are running the AVO site. We also have, and all of the opinions have said, that it is an ethical violation because the lawyers are paying AVO to recommend their services, which is not allowed under Rule 7.2. You can't pay for recommendations. And there's some other ethical rules, like, for example, lawyers have an obligation to safeguard client funds. The lawyers who participate in Bravo's service never have the funds. So Bravo has those funds and the clients could be left high and dry. But no, there's a client satisfaction guarantee. So the combination of the client satisfaction guarantee and the fact that Bravo recommends lawyers leads to an ethical violation under 7.2. It's under review right now, as you probably know.
Well, that's why I want to turn to Professor. You know, I just got a letter from, I'm making this up, a fellow over there just got a letter from the ARDC saying, come and talk to us about Bravo. And he calls you up and says, what are you going to do to defend me here?
Well, you're going to make policy arguments. You're going to say that 7.2 was designed to prevent what used to be called touters, guys who circulated around outside the misdemeanor courts and tried to, for a fee, and tried to get clients to lawyers. This is much more arm's length and regular, and it doesn't have the same dangers.
I know that there are a lot of lawyers, rightly so, worried about this, putting aside the fee-sharing subject for a moment, but just from a business perspective, and don't like the one group, Sokolov, I believe. There are big concerns with these groups, and you know, what are we supposed to do?
Well, you got to wonder about if they're extending legal representation at reasonable fees to underserved or unserved groups of the population, and the protections are in place about client fees and the like, client funds. Well, why not?
Okay. Well, let's see what the survey says. What? Let's see
The poll
what's
is going.
what the poll is going.
Right.
And right now, this is like being at a Bulls game. You know, when they have the three beans running around. Who's going to get the jelly beans or the Dunkin' Donut coffee, free coffee? All right. So A is 61%. B thus far is 14%. And C, no violations at all at 25%.
Wow.
So, you know, a lot of confusion in the bar about this.
There
so
really is.
What do you know, Jayne, about what is under review and
Well,
when
right
the review will be
now,
complete?
You may have heard that there's an association called the Association for Professional Responsibility Lawyers. They spent several years studying what's typically called the advertising rules and made recommendations to get rid of a lot of them and just go to the standard. Is what the lawyer says about their services false and misleading? That's what we should be caring about. And there's a real animus, as the professor said, saying, why are we stultifying lawyers getting the fact that they have services out to the public when at the same time survey after survey shows that it is up to 80% of the population that's not getting their civil legal needs met. So the ABA is now taking comments on some model rule changes. I wrote a blog post on it. You can find it on my website. I think it was February 7th. But if you have an interest, model rule amend at americanbar.org. Right now is the comment period. You should write in. It's my personal opinion, Bob. The rules need a major overhaul. They don't take into account technology the way citizens expect to receive services, legal services included. In addition, you should know that the General Counsel of AVO, Josh King, will be a speaker at the Commission on Professionalism's Future Law Conference this May 2nd here in Chicago. The formal announcement is coming out next week, but you have it here today. You can go on our website after this program and register for that conference. We're going to have 10 speakers talking about cutting-edge legal issues like this.
There you go. May 2nd, that was our commercial plug. We do have some questions coming in, but this is an important one. Yes, sir.
What about the AVO rating? The AVO rating scheme. If you buy a lot of advertising from AVO, then your attorney listing is rated as AVO rating 4.7. Which has absolutely nothing to do with your legal ability, with your success rate, with the number of times in court. It has everything to do with how much money you have paid AVO, or Bravo, pardon me.
Or Google.
Or
Okay.
Google or whatever.
I do know that's under review as part of the review. Is that right?
Yeah, and that is part of the New York ethics opinion that's in your materials. Rationale for finding that this was unethical because the combination of the rating, saying all of our lawyers are great, and this system was an unethical recommendation of a lawyer.
All right, moving on here. Let me one last thing. The slide was 61% of the audience was for
63.
63. Final vote. 63. He was illegally, unethically fee sharing. Yes, 13% for other reasons, and 24% stood their ground and said no violations. Okay, moving on to hypothetical number 3. Your Honor, coming your way. Okay, Attorney Adam defends client in litigation brought by the client's chief competitor in the judicial district that addresses e-discovery in its formal case management. Big deal now, folks, e-discovery. Opposing counsel drafts an e-discovery agreement offering the use of her vendor, jointly agreed upon search terms, and a clawback provision that would permit client to claw back any inadvertently produced ESI that was otherwise, quote, protected by law, end quote, protected ESI as it was called. Adams thinks the clawback provision will allow him to pull back anything, not just protected ESI, so long as he asserts it was inadvertently produced. Adam agrees to the proposal and subsequently receives the data from the vendor but shoves it in a drawer without reviewing it. Sometime later, opposing counsel sends Adam an angry letter accusing him of spoliation of evidence. Adam hires an e-discovery expert to conduct a forensic review of the data and the client's practices. The expert advises that the client routinely deleted ESI from its computers, resulting in gaps in production. He also advises that due to the breadth of the agreed-upon search terms, privileged information as well as proprietary information about the client's new products was provided to plaintiff, even though proprietary information was not relevant to issues in the lawsuit. Well, that's a mouthful, this case, but I got to tell you, that's a fair description of what's going on out there. What ethical issues are out there for Adam, Your Honor? Judge Dooling?
Probably everything Adam could do wrong, he did do wrong. I mean, this is a great example of our obligation as attorneys
A little closer,
That-
Judge. Microphone, thank
to
you.
present competent representation. Take that model, ABA Model Rule 1.1 about competence. A lawyer shall provide competent representation to a client. Competent representation requires a legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So you got to look at the type of case that you're going to go and try to handle. I mean, in the mass tort world, the number of documents is mind-boggling. One of the mass torts I had to go back and look. There were 30 million pages of documents in discovery. Individual documents from 300 sources in the defense company. I mean, you can't walk in and take that case if you're not in a situation to know what you're doing. And let's just look at Adam. He starts it out at the beginning with this clawback agreement that he doesn't even read. I mean, you have a responsibility and competence also to keep up with current technology. ESI isn't really that current. You know, it's been out there for probably 10, 15 years. And you can't take cases you don't know what you're doing. So he doesn't even read the agreement he's promising on behalf of his client to provide this information. He gets the agreement and he agrees to the proposal, doesn't take a look at the data that the vendor, the person going through under the search parameters, is going to produce. He just sticks it in his drawer. I mean, madness. And then the other opposing counsel accuses him of doing things, and he doesn't do anything about it with the company. I mean, if he knew what he was doing, if he was representing companies in this mass tort litigation, or any company in any e-discovery with ESI, you have to tell the company to put a litigation hold. This company here, they're routinely, under their practice, deleting things they don't think are relevant. So if you knew what you were doing, you would have called the company and said, hey, litigation hold, we're getting sued, you got to stop destroying all that stuff or we're going to have problems.
Judge, let me jump in here and ask you. No, I appreciate it. Because, you know, it's interesting when I talk to people about ESI, the comeback is, well, that really only is applicable for the big-time law firms and practitioners, and that's just untrue. And that's where Professor will get to that in a moment and saying, how do we defend ourselves? But, you know, the ESI practice is really applicable to the small practitioner. And Ms. Reardon mentioned this over the lunch hour about how technology is changing the practice. So Professor, what do we do when I come to you, I took on a case of a small corporation, rather than having 3 million documents that have 30 million pages, that's what we're talking about here. I'm a small practitioner, but I'm dealing with a company that has a complex manufacturing business. What is my obligation to go out and get the relevant knowledge and expertise that is going to be required for me to represent them? All I used to do is I wrote their stock offering and their bylaws and all that. Now it's a different day. Professor, have you seen any of that? What do
you better hire an associate who is under 30, who is a online native, not an online visitor, for whom this sort of material is more second nature. You're going to need to associate either with a lawyer or a specialist who is going to be able to educate you as to the necessary technological aspects, including the e-discovery part of the case. Otherwise, you are incompetent. And for us, the bad news is that Illinois, as of the 1st of January 2016, added in the comment as a element of competence that one must understand the benefits and risks associated with the relevant technology. So now in Illinois, that's part of our obligation under Rule 1.1, the general competency obligation.
Wasn't there a state ethics opinion on that too, Professor?
I don't know.
Or a case also, the A&M case, is that?
That's right. I don't think that was Illinois, but yeah, a lawyer was sanctioned because he basically was doing a lot of what Adam in our hypothetical was doing. He was just at sea in the technology surrounding his case, incurring great costs both to the other side, the court, and his client. The court just said, no, that's sanctionable.
All right, from the internet, a question, Pam?
Yes, we have lots of questions flowing in, and actually going back to the previous issue, Christopher is asking, as Director Reardon mentioned, that is AVO being unfairly targeted? Because what's the difference between super lawyers and leading lawyers and participating in that?
Well,
We're back on the last typo, but
Yeah.
that's okay. It's a great topic.
I think the super lawyers and leading lawyers are simply lists of lawyers who have achieved a certain,
Eminence?
eminence, thank you, from the Chicago Lawyer or whatever. The difference with AVO is they're providing a platform to actually match lawyers and clients and prospective clients. So it goes a step further.
So then Michael is asking then, if you then are paying for this fee to AVO, and you're calling a potential client who's describing a legal problem, and the lawyer paid a fee for that, then how is that not violating solicitation rules?
Because the solicitation is actually being done by AVO. AVO's not bound by the ethical rules, right? So under the hypothetical, the lawyer was contacted on behest of a client. AVO provided the platform.
Thank you.
A lot going on there. Okay. Let's move on to the next hypothetical, number 4. The investigation. Your new executive is concerned whether your pharmacies are abiding by the applicable regulations governing filling prescriptions. One of the in-house lawyers suggests that you do a study. And if I run it, then the results will be privileged. The FDA has called and suggested it's doing a preliminary re-review of the pharmacy's procedures. You decide an investigation would be in order. Let's have one of us do it rather than hire expensive outside counsel, end quote. That'll save us loads of money, end quote. The investigation proceeds and it becomes necessary to interview a number of employees. Are there any special precautions that you have to take relative to a whole lot of issues here during the interviews? What do you do if a lawyer says, one of the interviewees says, I'm feeling uncomfortable, I need a lawyer, do I need one? During another interview, you have a different pharmacist saying, I know you won't tell anyone, but I have been having lots of trouble with my back recently, and yeah, I've become addicted in the process of these painkillers. You complete the investigation and the results are mixed. You know the report is quite critical. The CEO says, I can take care of all these problems, no reason to bother the board about this. And finally, the FDA completes its investigation and announces it will institute litigation unless the company turns over the investigation and all other privileged information related to this matter. Professor, what do you need a white-collar crime lawyer here, sounds like.
There's so much twirled into this, it's hard to know, but let's start. One thing the lawyer's got to be careful about is getting clients he doesn't want to have. So an attorney-client relationship is created when a lawyer acts in a way that the person he's speaking with could reasonably conclude that he is their lawyer, he's offering representation. Usually it's a meeting of the minds, but if you act like someone's lawyer, that person is entitled to assume that you are. So these pharmacists, we sometimes call this corporate Miranda. It's usually involving executives, but here it's the pharmacists. You have to make sure, it's your obligation to make sure that the corporate employees you're talking with understand that you represent the company and not them.
This could be happening in Schaumburg right now with just a small company, right? I mean, there's no difference between it. Here you got a big pharmacy or pharmaceutical, but it could happen in a small business.
Absolutely, and at least in my experience, it's more likely to happen in a small business where people don't make this distinction between the lawyer for the entity and the employees of the company. So if you do everything right and you say, I'm not your lawyer, I represent the company, I'm conducting an investigation for the company, so I am not your lawyer, then those employees are non-represented parties within the meaning of the rules. So they're governed by Rule 4.3 of the Rules of Professional Conduct, and your main obligation there is not to give them legal advice if there is some likelihood that their situation could be adverse to that of the client you represent. So here, there is that possibility. These pharmacists may have been violating regulations in a way that could redound against the company. And so it is, you may not give them any advice except for one, get a lawyer. The rules of professional conduct always allow you to give the advice to anyone to go get a lawyer.
Jayne, what's your take on this? And if you could, comment about the need of the lawyer, if it's a GC, to notify their own insurance carriers or any of the other things that you think they have to do.
Yeah, they would have to do that. I'm also want to point out the whole situation with CEO saying, I can take care of all these problems, don't get the board involved. At that point, if the attorney is representing the organization, they may have an obligation under the rules to get the board involved and notify them that their CEO is doing something that can adversely impact the corporation. And so, that's provided for in Rule 1.13B right there. And the comment 2 also, I believe. I think getting the malpractice and carrier involved would be a good idea.
All right. Now, that particular hypo, folks, did not have a poll, so we didn't get to vote on that one. But this hypothetical number 5, we do, make them go away. Acme Corporation is constantly being sued by Caldwell and Moore. The client insists it will settle the latest case but wants to stop the frivolous litigation. Acme proposes 3 options to put an end once and for all to this madness. A, get opposing counsel to agree to this language. Quote, plaintiff's counsel further agrees to not, at any time in the future, accept cash compensation or other consideration from a law firm or any other entity or individual in connection with the advancement of a complaint, claim, or suit against one or more releasees that relies on the theory of liability identical to or substantially similar to a theory advanced by him in the legal action, period, end quote. Only a law professor could have written that one. All right. 2, number B.
Appellate judge.
We pay either plaintiff or his lawyer an extra $100,000 if the lawyer agrees to stop suing Acme. C, insist that any settlement with the plaintiff be conditioned on the plaintiff's lawyer never disclosing that he brought a case against our client or the result of the case. Wow. Judge Dooling, what do you think about that one?
I think that A and B you got to say no to because of the Illinois rule.
Judge, a little closer, please, to the mic.
I think you have to say no to A and B because of the Illinois rule on restrictions on the right of practice. A lawyer cannot participate in offering
Push
or
it a little
making.
closer to you if you can. Sorry.
What's the problem here?
The
The angle of the mic?
The people on the web have to hear her,
Okay.
so that's good.
Thank you, Judge.
Thank you.
So go ahead. Say that again, Your Honor.
I believe that the answer to the question is in Rule 56B, that A and B would be no. You can't give them money to go away. You can't get them to promise not to practice, because if you...
Well, wait a minute. That $100,000 looks pretty enticing. Can't I just take that $100,000 and call it a day and let Acme out? Get them out of my life?
ARDC? Sure. Because someone might well bring an action against you because the rule is you can't accept that money and money like that can't be offered. As to C...
Yeah. No. Keep going. You have the floor.
Thank you. As to C, I think it's a little bit more open. The confidentiality agreements are kind of interesting.
Oh, they've corrupted the civil justice system. Here, I'll tell you what just happened to me. Okay, I had this motion filed, and they want to say, well, it was in a mediation brief actually, but they've now converted it to a motion where they say that, hey, in these other cases, Clifford asked for different sums of money. These are all analogous cases, and this just proves that his settlement demand here is grossly unreasonable. And I said, well, wait a minute. What about the fact that nowadays all these settlements are so secret? The only people who, in a tort case now, the only people who know the value of a case anymore are the insurance companies because they're the ones paying, that the market has been corrupted by this confidentiality. I mean, didn't you see that as a judge when people would come to you and you'd have a pretrial conference and they say, well, why is their demand so high, Judge? We can't find a single verdict or a single reported settlement that's anywhere near what the plaintiff, Mr. Bierman, is asking for in this divorce case.
Absolutely. Because, and all you could, they'd run the jury verdict reporter and say, here's the proof, Judge, here's what it's worth. But I came up, I'm so old, that when I started in the law division, Judge O'Connell was the head of it, and he was deaf on confidentiality agreements. He said, no dice, it's a public court, it's a public forum, there's only very rare exceptions then where you should allow a confidentiality agreement. But just because I don't allow it does not mean attorneys don't do it on their own.
Well, they have to do it unless the court prohibits it, right?
Yeah,
Because
well, we'll
if it-
come back to that.
Yeah.
Jane, what do you think? I don't know about that. They have to do it. What, you know, they're,
I'm
this
not
isn't a
saying they
program.
have to do it, Bob. I'm saying I won't agree to a confidentiality agreement and a settlement dismissal.
Okay, got it. Jane, what do you think?
No, I'd like them to go away, but, you know, they're
Well,
allowed.
you could do what they did in South Carolina. They've, in the federal system, they've got a rule that says they're illegal. Why
That's
can't we
what, that's
do
what
that
you
here?
have to do. Otherwise, lawyers are forced into
What's
doing
our
it in the
poll
interest of
say
their
here?
clients.
What's our poll say? I think the poll, so there's a D here, which is none of the above, but the poll, the D says 27%, so 3/4 of the people agree. 72% agree with C as being the correct answer. And I don't want to make this a program on confidentiality, of course, but there are issues. I think there are even taxation issues associated with the confidentiality agreements and where you paid any extra money, again, in a tort case, because it's a tax-free transaction, and then all of a sudden now we're getting paid extra money. Well, that's not part of the tort claim, or is it? So that's for the next program. Okay, so final results, 72% for C, none for A and B, and there we go. And how about hypo number 6? This is a good one. Advice to counsel. Excelsior Corporation comes up with a great plan to save on taxes, an approach that was recommended by Martin & Martin and Fox. The CEO, CFO, and GC sit down with Martin to go over the proposed idea. The CFO is skeptical, but Martin assures him that the idea will fly. The company pursues the plan, and 3 years later, the IRS comes to the investigation. They tell the CFO he is a target of their investigation, as is the company. The CFO goes to the GC and says he should not have any liability because they were advised by Martin & Martin and Fox. The GC reminds the CFO that he cannot tell the IRS about the Martin opinion because that is an attorney-client privilege matter. The CFO stutters, quote, "But we never would have done it without Martin," end quote, to which the GC replies, quote, "But the company has not waived the privilege and therefore you are barred from disclosing anything," end quote. Is the GC correct, Jane?
Well, the GC represents the company.
We're polling here now, folks,
Go ahead
so
and poll, yes or no. I think there's a big problem with the first meeting. The GC sat down and should have anticipated the possibility that the officers would come to be in conflict with the company. And there's an obligation under Rule 1.13, and it makes it clear in comment 10 that he or she should have clarified their role, who they're representing in that meeting at that time. Didn't do it.
well, doesn't the GC always represent the company?
The GC does represent the company, but some of the officers might have assumed, based on the fact that the outside counsel is there, and based on this comment that he comes up now, we wouldn't have done it without Martin's advice, that they were covered by attorney-client privilege.
Professor, what's your take on this?
On that first meeting, courts are pretty unsympathetic to high executives who say, geez, I thought it was my lawyer, not the company's lawyer. The cases I've read, the courts tend to say, oh, come on, you're the CFO. You knew that the lawyer represented the company, not you. So that would still allow the company to be the party that held the privilege.
Well, let me ask you though, wasn't it the lawyer's obligation in that meeting to, a CFO's a CFO. I sat in a deposition yesterday with a CEO who kept saying, you're throwing lawyer words at me. I'm an engineer. I don't understand this stuff. So when in that Martin and Fox, didn't they have an obligation to make it clear right up front whose lawyer they really were?
Yes, but I think they may not be successful in making that argument later under circumstances like arise in this case.
Yeah. In our poll, we've got that the 31% are answering A, and I guess that's that the GC is correct, and not correct. We got the rest, 69%. I'm always so glad that we add up to 100 here.
There's some case law on this, on the question of who holds the privilege. There's a case called U.S. versus Wells Fargo Bank in a 2005 case following a Sixth Circuit case, and they basically said the general counsel is correct. And in a civil case, the attorney-client privilege held by the company trumps even a good faith attempt to rely on a defense of advice of counsel. The open question, Swidler and Berlin versus United States, is if it's a criminal case and you want to break through the attorney-client privilege to offer a defense in a criminal case, there's a footnote in that Supreme Court case saying that's an open question. But in a civil case, the authority seems to agree with the general counsel here.
Okay, well, thank you. Question in the room. First one, the gentleman next to Mr. Bierman.
Yes, it's going to be a confidential communication that the CFO and CPR are being non-party, albeit written.
Robert?
Yeah, it's still covered by both confidential and privilege, but it's the company that holds to whom the lawyer owes the duty of confidentiality and that holds the privilege, because the company has to, of course, communicate through human beings.
I first saw a hand on my left and then one on my right. Yes, sir.
There is no necessary inconsistency between the two positions, because even if the company is the one that has the right to the confidentiality, the general counsel's behind the eight ball for not making it clear. Even if the courts aren't sympathetic, under the rules, the general counsel's going to be in a heap of trouble for not dotting the I's and crossing
Yeah,
the
he
T's.
could be
at the
liable.
initial.
There's a
Right.
malpractice action here possible.
Okay, up in the back row. Yes, sir. Then
The
we'll move on.
question really is, if the IRS is after the CFO, this is not a tax case, this is a fraud case. Isn't there a crime and fraud exception that's just sitting there?
It depends on the state of mind of the so-called of the client. So is the client seeking legal advice in order to commit a crime or fraud? I don't see that here.
Okay, interesting. All right, well, moving on. Hypothetical number 7, another polling question. The attorney work product. Lawyers are hired to defend Colossus in an investigation of its compliance with auto safety standards. In connection with that investigation conducted by an outside counsel, a calculation is prepared of possible damages the company might suffer if it turns out that its ignition switches are defective. Ooh, this is a plaintiff's lawyer's dream. The Bureau of Consumer Affairs institutes litigations, and the company puts the damage calculation on its privilege log as work product. The Bureau files a motion to compel the production of the investigation's work product. Should the judge grant the motion to compel? Your Honor, what would you say?
I would say I'd have to look at what's in the privilege log before I can make a decision. I guess we should say this question, the facts here, assumes there was a discovery request for it. So it's not a situation where somebody just threw something on a privilege log without thinking about it. But the question would be then, was this prepared, these documents prepared for anticipation of trial, litigation, and contain the attorney's impressions?
Well, Judge, you handled some really big of these mass tort cases, and when you, I mean, didn't you really see, I'm being a devil's advocate here, a lot of abuse of the attorney-client and work product doctrines that to shield damaging information from discovery that really is discoverable? And
No.
No.
You know, I mean, I
All
was
right.
so blessed, sorry, Bob, but I was so blessed with really, really great attorneys on all my mass torts that these individuals talk about civility
Right.
and their abilities. They'd come in, and if they had an issue about work product, it came up so rarely, even with these 30 million documents. They'd come in, they'd make their arguments, they'd give me the case law, they'd hand me whatever they wanted me to look at. I'd look at it, issue a case management order, and they'd go from there. So I didn't see that.
Professor, what's your take on this?
I think what the author of the PIPO wanted to raise is the line between absolutely protected work product and work product that is protected only in a qualified way that you can break if you have a need for the facts. And from these facts, you can't really tell which one it is.
Right.
The Supreme Court declined to take cert in a case like this a couple of years ago, so we're still sort of in the dark as to where that line is. A lot of variation.
All right, the audience on our poll is 28% think that the motion to compel should be granted. Those are all the plaintiff lawyers. And you got 72% say no. Okay, moving right along here. Number 8, hypo number 8, take over this heartburn. Fox is worried that he is going to be put out to pasture as an unproductive partner when he receives a call from Lord Silversmith, the British takeover tycoon. The good Lord asks Fox if Martin and Fox will help his company, Silversmith Limited, take over Target, that famous conglomerate. Fox is thrilled that his career may be resurrected when he receives a call from a lawyer he does not know in the Martin and Fox Miami office. So he's there cackling in New York, and now he gets a phone call from a partner in Martin and Fox's Miami office. That lawyer introduces himself, tells Fox how excited he is about his possible new engagement, and tells Fox he is doing work for Music Unlimited, which is a third-tier subsidiary of Target. Quote, I hope this does not affect your ability to take on this new matter. Does it? Yes? No? Or C, it depends on whether the Music Unlimited representation is adverse to Target. There's a poll here. Jayne, what do you think about this?
Okay, so while they're polling, of course, we've talked in many of the other hypos that a lawyer represents the corporation, but the issue here is a lawyer who represents a parent doesn't necessarily represent a subsidiary or an affiliate organization. That's Rule 1.7. It lays it out very clearly in comment 34. So the issue here most likely boils down to, is Fox's client, Silversmith, in some sort of adverse relationship with Music Unlimited specifically? I don't think that there would be a problem just because the sub is, or Music Unlimited is a subsidiary of Target, but if the representation would be adverse, then you can't put it. We don't know that from the hypo.
Well, Judge, Fox did take the case, and we found out about it, and I come in on a motion to disqualify him before you because of this situation. What's your ruling?
I'd have to take a look at if there's an adverse relationship that Jayne was talking about. Before I could do anything, I'd need more facts.
Does this go to what, Professor, you were talking about a little bit earlier when you said you can maybe pull back the onion a little bit more and get into some of the nitty-gritty, and that might help you?
Yeah, the black letter rule is if you represent one of a corporate family, you don't represent everybody else in the corporate family. But then the law gets very complicated if the two companies are intertwined, if they have the same internal structures, then you could say, well, one is the alter ego of the other, and so represent one means you represent them all. It doesn't seem that that's true here. It seems that these are big companies.
Okay, and in our polling on that one, I believe the vast majority believe that B is the correct answer. I think it was, pardon?
71%.
71% thought that there was no problem that couldn't be worked out. I mean, if you can't work out the problem, how are we supposed to have all these, young lawyers getting paid? Come on. Oh, this problem here. All right, hypothetical number 9. There we go. 29%, 71. Do people in the audience like this polling? I mean, it's new for us this year. We're tinkering with it. Okay, thank you. Hypo number 9, the false economy. Here we go. Colossus again. They're fed up with the high cost of hiring Caldwell and Moore to handle their serious but similar litigation involving their power tools. Colossus informs Caldwell and Moore that it will continue to use the law firm for the trial of these cases, as well as any pretrial mediations or settlement discussions, but because Caldwell and Moore has started paying its young associates $180,000 a year, that does not apply at Clifford Law. Colossus has decided to outsource all proceedings before that time to a Philippine law firm, which charges significantly less per hour for what Colossus describes as routine pretrial work. You will be our local counsel for the Philippine firm, but they have agreed to accept responsibility for everything up until settlement discussions or trial. Does Caldwell have any ethical issues in accepting this arrangement? Yes, Caldwell may be held as ratifying the pretrial work and unauthorized practice of law by the Philippine firm, or no, the client may assign portions of a matter to whatever legal counsel it chooses. Professor, what's your take on this?
Well,
this is a polling slide, too.
This one's kind of tangled as well. 1.2c says you can accept a limit on representation if it's reasonable, so we're just going to be your trial counsel. It's not clear whether, in this hypothetical, the law firm has any supervisory responsibility over the Philippine law firm, so it seems like there are two distinct retentions by the client. If they did, then Rule 5.1 would require them to have supervisory responsibility over the Philippine law firm. A real problem is the unauthorized practice of law issue here. Rule 5.6c allows other lawyers who have licenses in the United States to be appointed pro hoc vice in another jurisdiction or affiliate with a local lawyer. But these Filipino lawyers may not fall within 5.6, and therefore this law firm may be assisting the Philippine firm in the unauthorized practice of law, which you can't do because you can't assist some other lawyer to violate the rules. So the problem is, I think, the retention of the Philippine firm in a context in which the rule may not allow them to do it. Now, if you're in federal court may say, I don't care what your local rule says, we're appointing this Philippine firm to represent this client pro hoc vice in our federal court, but they're unlikely to do that, I think.
Executive Director Reardon, what do we got? What's your
I just wanted
take?
to add one thing. The Rule 5.3 was modified in Illinois recently, and that now lays out that lawyers have responsibility regarding non-lawyer assistance. This isn't really directly on this hypo, but it comes up a lot, particularly when we were talking about in an earlier hypo about lawyers need to understand technology. We have an obligation to supervise our non-lawyer assistants, whether they're software vendors or e-discovery vendors or what. And we really need to be aware of that as well.
Thank you. And then our poll, 69% believe yes, Caldwell has been ratifying the work of these people who don't have a license here, and 31% think that they do not. Any questions on this? I'd be curious to know why 31% think no.
We have one here from Darren who's asking, when the Philippine firm messes up the case, will Colossus be suing Caldwell?
Yes, yeah, 70% of the people think yes. Mm-hmm. There you go. I wonder if that's covered then under your malpractice policy, though, right? Because how about that one? What would the ISBA mutual say about that?
Sound like a judge.
All right. Okay.
Is there a question back there?
Yes, sir. Ma'am?
And if we can make sure the audience is asking on the web that either Bob, that you repeat the question or the microphone be in the person's hand.
Okay, great.
So, separate and apart from what the rules of professional conduct require, every time I've been asked to be local counsel here or have engaged local counsel in other jurisdictions, the court's rules impose obligations on the local counsel to superintend what the out-of-town lawyer is doing. And so I'm not sure that this hypothetical is addressed solely by reference to the lawyer conduct rules in whatever jurisdiction you're talking about.
Professor, what do you think about that?
Yeah,
I think everyone,
I
he used the
think
mic
that's-
there.
I think
Yeah.
that's right. If the court's rule basically puts that responsibility on local counsel, and your local counsel for the pretrial part of this, rather than just coming in at the trial level, which depends on what the agreement is with the client, then that would both make you liable in malpractice, and you'd have a 5.1 responsibility to supervise.
But I'll bet, if going to Judge Dooling's experience with those millions of documents, I mean, I don't know this, maybe you do, Judge, but I would have to think that the companies involved there found a way to manage those documents to lower their costs, to get them organized. And there doesn't strike me as anything wrong with that, provided the law firm appearing before you is vouching for the quality of the work and the representations that are may be made to the court. Is that how you viewed it, or was there ever talk about that?
Yeah, I mean, they'd have to lay all this out for me, the retention policy, if we had fights about whether the litigation hold, when it should have started, different things like this, but it all came up with motions, and everybody would have to turn over all their processes and procedures to see if it indeed was fair.
We have some questions here on the web related to this still. Andrew is asking, what if the company is sued in the Philippines? And Sam is asking, a number of corporations, offshore legal work, are sending their in-house counsel work to India. Does that constitute the unauthorized practice of law?
Professor?
It depends. You have to read Rule 5.6 very carefully.
I know where to
and-
go for the depends answer.
Yeah.
If I go to the left, I get a ruling. All right.
If judges can do it, we can do it too. It depends on whether or not there are situations in which a Illinois corporation could have its legal work done in India, but you have to look very carefully as to what that legal work is and whether it requires competence in Illinois law and whether or not the Indian firm can provide that.
Okay. All right. Well, then let me move on then, folks, to number 10, expert at what? Victory was so sweet. The jury came back in less than an hour. Verdict for your client, big bucks. The jury especially liked your charming expert witness on the key damages question in the matter. You are just putting the finishing touches on your appellee brief, always better to be the appellee, on your appellee brief attacking the loser's frivolous attempts to overturn the verdict when you receive a call from the consulting firm that provided the expert witness. The CEO of that firm tells you that the firm has just discovered, much to its surprise, that your expert witness never earned a PhD in economics as her resume indicated. Quote, I am sure with your strong case that wouldn't make a difference, but we thought you should know. It is a little embarrassing. What would you do? A, nothing, because you agree with the CEO that the expert's credential would not have affected the outcome of the trial. B, you file a motion in the trial court to correct the record. Or C, you drop a corrective note into the appellate brief and file it. Okay, let's have, there's a poll going on here. Judge, you heard about this through the grapevine. What would you be doing? Yes?
I would, A is absolutely out, you can't answer that. Jurisdiction, it depends where you are. Were you in the trial court, were you in the appellate court?
Oh, we're in the
But
appellate court now.
I wouldn't be dropping a note. I would go to the other side, to the other attorney, and make the court aware of it. Why? Because you have Rule 3.3, candor toward the tribunal.
Well, where's the line drawn? Okay, so I want to change the hype a little bit. This expert completed all the credential for the PhD, had everything, but didn't show up at the convocation. They didn't send him the document. You know, I mean, just a little off here. I mean, where do you got to go with that? Jayne, what's your take?
I guess you're making an argument. It wasn't a material piece of evidence, and I think that's going to be a tough argument to make. But you'd probably be successful. Most people, maybe not.
I don't know about that one.
The obligation
I'll tell you what
continues.
caught my eye about this hypothetical was the jury came back in less than an hour and the plaintiff got big bucks. That does not happen, okay?
That's usually defensive.
So your obligation to correct the record lasts until the end of the proceedings, and comment 13 says that's until the time for appeal has passed or the appellate court has affirmed or reversed the decision below.
Okay, what's our
Then
poll
the question is,
showing? Yeah, go
what
ahead,
would
Jayne.
be, so you have an obligation then, assuming it's material,
Right.
and we're still in the proceeding, you have an obligation to take remedial action. The question is, what would that remedial action look like?
Well, according to 92% of our people in the audience, it's file a
Back to the
motion
trial
in the
court.
trial court to correct the record. Yeah, but the trial court doesn't have jurisdiction anymore. Once you filed your appellate thing, the jurisdiction is lost. But I think the consensus is that you'd file a motion somewhere.
Gotta do
You gotta
something.
get some direction, right? Okay, that's good. That's a good one. Any questions on that in the audience? I thought I saw one hand up there. Mr. Appeal, Mr. Hugh Griffin in the house. It's a tough one. Hugh, take the mic, please. Right behind you to your right.
I mean, kind of it goes back to, couldn't you argue there was a duty on the other side to explore the credentials of the expert if it wanted to do so? You don't have to take anybody's word for it. Sometimes we find stuff like that hey, you didn't
Right.
really get your diploma. But,
Yeah.
it's funny. I mean, you could take this.
Well, there are a lot of things there. You could sue the expert service. I would assume that would be one of them, right? That they didn't do a proper background check. They jeopardized my client. I've got this $25 million verdict now that they say that is in jeopardy, so I want to sue them. I want to sue the expert. I'm going to get sued by the client for legal mail. They could make that. It's a very complicated picture. I said the question of the hypo, though, is what's the obligation of the lawyer at that moment in time who gets this information? And I think, as our panel is saying and the group in general, you got to do something. You just can't sit on it.
I might add another D. I might add the fourth one would be you tell your opponent, and let him decide what he wants to do with it. He can bring a 214-01. I mean,
Okay, that's a good one.
We had a case where a guy claimed he won the Medal of Honor, and it was a single car accident, and so his credibility was key. And we found out after the trial, the guy he said he was in Vietnam. He never left the United States. He was in the Army, but he never got to Vietnam. He never got a Medal of Honor. So we brought a 214-01, and ultimately it was set aside. But I think I would just give the information to my opponent, let him bring some motion, and then we'll litigate that.
This one is if you open this up, like right now, and if you talk to folks trying cases on both sides here in Cook County, all of the social media stuff and what you find out afterwards about whether it's a juror or a doctor or a plaintiff, there's a lot of work here for the professors who consult lawyers on their ethics, that's for sure.
I mean, where do you draw the line? You could
God
take
for that.
Any witness at trial, you might decide, if you looked at the transcript and thought about it, well, gee, I think this guy overstated it a little bit.
Right.
Well, that's going pretty far, isn't it, from saying you have a doctorate and this could be the key witness, and I think you have a responsibility not to be candid with the court and tell them about false evidence, because the appellate court isn't going to know. I mean, if you didn't know, it's a different story, but once you know, aren't you somehow responsible for that and responsible for your experts? I saw it all the time with the experts.
Well,
And I think you just found out how that would go, that ruling would go. Okay. Let's go. All right, very good. All right, Hypo 11, invading the privilege. Plaintiff's attorney Raj represents Siri in a wrongful termination case against her employer, Bystander Bank. The CEO of Bystander is also named, coincidentally, Siri. One day, Raj receives an email from Bystander's counsel, and the subject line reads, quote, preparation for the deposition of CEO Siri, end quote. No doubt about that. What should he do? Open the email and read the information. It'll help him nail the bank's witness at his deposition. B, forward the email back unopened and tell bank's counsel of the misdirected email. C, call opposing counsel and tell her about having received the email. And I'll throw in Hughes D, anything else that might come to mind. Other. All right, so we got a poll slide going here. Jayne, what do you think about this one?
Well, there is a rule on point here. If the plaintiff's attorney realizes that if an attorney realizes that they got a document in error, Rule 4.4b makes it unclear what they should do, but here's what it provides. A lawyer who receives a document relating to the representation of the lawyer's client and knows the document was inadvertently sent shall promptly notify the sender. Obviously, you're going to know it's inadvertently sent, but all the rule requires is you notify the sender, which I think is quite
Wow. Robert, what do you, now here, could I take a peek, Robert? What do you think, Professor?
The rule would not prohibit you from taking a peek, and strangely, almost uniquely among the rules, the comment says what to do, whether to take a peek or send it back unopened, is, as they put it, a matter of professional judgment reserved to the lawyer, which suggests that you don't even have to check with your client about this. It's your ethical call in the broader sense of ethics. Now, once you reveal this to the opposing counsel, Rule 26 in the federal system and 201 in the state system would allow your opponent to say, don't read it and send it back to me, and you'd be obliged to follow that instruction, at least maintain it sequestered without revealing it.
And I'm pretty sure that if you did open it and say, no, I didn't really open it, that you could check the metadata on that.
I expect so, yeah.
And I'll bet you they, even though you said it, what's it, confirm but verify, or what's that phrase? Trust but verify. Trust but verify. Okay, so now our audience says B, 56%. You forward it back unopened and tell the bank's counsel of the misdirected. And C, and that's a go. Call the opposing counsel, tell her about it, and see what she wants to do. That would be a Hughes' favorite response, right? Okay. All right.
I would just be wondering whether people think it would be a violation to not read under the circumstances. It doesn't say in the rule that you can't read it.
Well, but it does, I hear that, okay, but there's no doubt in your mind that this is not directed for your Siri. It's because it says right there, CEO Siri, so you know it's not for...
The point of the comment is to say you will not be lacking in diligence if you do send it back unopened. So it's your call. It's
Okay.
not your client's call. And that's, I think, unique among the rules.
Now, is that limited to Illinois, do you think? Or
No, that's from the model rule.
that's from the
Yeah.
model rule? Wow. Okay, well, and again, 54 to 44. What happened to the 2%? Undecided, I guess. Okay, hypothetical number 12. Truthful client. You are in a mediation and you're meeting ex parte with the mediator, who's appointed by the court. The mediator opines that if you are going to succeed, you are going to need a really outstanding expert. At that point, your client interrupts saying, "We have hired Dr. Mendelson from Marquette University, the leading expert in the field." Bless you. All right. You know that no one has ever talked to Dr. Mendelson. What do you do about it? A, nothing, because you and your client agreed that you would contact Dr. Mendelson if needed down the road. B, call your client out of the room and persuade him to go back in and admit that he lied. C, correct the facts right then and there in front of your client and the mediator. All right, we got a poll going on this one as well. Your Honor, how would you handle here? Your Honor, you're now retired from the bench. You're a judge in mediations if you want to do.
No, I'm not. I'm in my gap
I
here.
know you're in your gap here, but you might become one. This happens. This could be real. Okay, what would you do here?
Well, I guess the professor explained to me that a mediator doesn't come under the tribunal, because there's a rule here about you can't lie to a tribunal, but it doesn't really cover mediators, because you wouldn't be a judge. But what it does cover, one of the other rules, that you can't lie to anyone. What is that, 4.1?
4.1, yeah. So 3.3 doesn't apply, which is candor to the tribunal, but 4.1 would apply.
But, on top of everything, it's just silly, because the next question the mediator would say was, can I see your 213s? I would, if it was me and it was my client, I'd just turn and say, we talked about him, but we never hired him. And just right in front of the judge, and,
But wait a minute.
You're used to dealing with clients, I'm not, but it just makes it better.
Yeah, but Judge, here, a lot of lawyers in this room and on the internet go to mediations every day, and no way, shape, or form am I believing that my opponents are always telling me the truth about stuff.
Well, you believe the attorneys are, but the clients aren't. I don't see the big deal there. To me, the attorney's reputation is the most important thing. And I understand there's business aspects to it too, but you got to live with your reputation the rest of your life, and just say to the client, no, we'll get it talked to him, because it's going to come out. The judge is going to say, what did Dr. Mendelson say, would be the next question. Oh, you got him? What are we going to do?
Well, that's privilege. I can't talk about that right now, Judge.
Why are you here for the mediation? We gotta, and that's the thing. It's controlling clients, and I never did it, except for, in federal court with the county. So I don't have that perspective. I have the perspective of seeing it in court when you have to control your client, and I've had cases that they have completely run amok. I had a case where they illegally wiretap the treating doctor, and then they keep the illegal wiretap because they want and on the wiretap, the recording, the lawyer, doctor, decedent's son is telling him, this is the way you should testify, and then he keeps the recording. Why do I ever see it? Of course, he never tells his attorney, the plaintiff's attorney, about it. He keeps it, and then the case goes on. It gets assigned to me for trial. At trial, when we're doing motions, it comes out that the day before, the client turned over the illegal wiretap to the attorney because he wanted to impeach the treater doctor at trial. You got to hold on to you have some responsibility for watching what these people are doing.
Well, 9% of the people think you do nothing here on our survey. 50% of them say you call your client out of the room and persuade him to go back and admit that he lied. And 40% correct the facts right then and there in front of your client and the mediator.
No, I don't think, that's awfully harsh, that second one, to tell him to go back and admit that he lied. You can be a little more deft than that in the meeting.
Misspoke.
Yeah,
Current
you could sort of take the blame yourself. You could say, in fact, Mr. Mediator, we haven't really contacted that person yet. My client was in error on that, something like that. But you can't. I think you can't let the matter stand.
Well, then here's a question, and actually, it's not, Professor, it's not on the list of things that I think you looked into here, but on this topic, where is the line drawn about a counsel on either side of it to be acting in good faith in going into these proceedings? I've got a mediation coming up that's a court-ordered mediation. I talked to the defense lawyer last week who told me, no way, no how am I going to ever offer you any money on this case. And I said, okay, fine, why are we mediating? Oh, we'll go in good faith. We'll go in good faith. Well, what? Okay. Come on. Doesn't she have an obligation? She can go there and pretend that she's there in good faith?
There's not a really significant interest in having something like the NLRB obligation to negotiate in good faith in these kinds of contexts. There's no enforceable obligation, although some courts have basically expressed a lot of unhappiness for people who have that view.
Okay, moving right along. Hypothetical number 13, no polling here. Clearing the record. Lasco Investments is being investigated by the Securities and Exchange Commission. The focus of the investigation seems to be a particular employee, one of Glasgow's Investment's most productive brokers. In-house counsel for Glasgow is handling the investigation, and she gets the idea that she will check this employee's Facebook page. Much to her surprise, she sees some pictures that give her pause. Glasgow's straight-laced employee is not so straight-laced after all. General counsel immediately calls the employee and tells her to take down those pictures before the SEC gets to see them. Any ethical problems there, Ms. Reardon?
Well, obviously, this comes up a lot, that you are not happy with social media postings of your clients. So I don't think there's a real problem with having them take down the pictures, because postings are often taken down. Where the problem comes in is if they're destroyed or you fail to preserve them. If you anticipate litigation, obviously you can't destroy evidence, and the SEC is going to ask to see them, whether you've got them there or not. So you have to make sure that you don't get into a situation, and I think there's another one here, where your spoliation of evidence could be.
Right. Okay. Deb, what's your take on clearing the record?
What Jayne said is exactly right. I guess the question would be, obviously you can't do it. Obviously you can't do it if there's a discovery request out there, but at this point, I don't even know what it is about, the pictures, but I think you have to, if you do take them down, you have to put them somewhere and save them.
Well, in with the websites, you have the Wayback Machine, but where you can go check out what someone's website looks like the day of a given event. I mean, we get it all the time in some of the aviation cases when a crash occurs, we go to an interview and people will tell you who the other lawyers are on the other side, and you check out their website the day before the crash, and they don't even list themselves as doing aviation litigation. And the day after the crash, they are like the world. So that's what's going on also with social media. You have to pull that stuff. Okay, let's go to hypothetical number 14. Oh, apologies. Thank you. Yes, sir.
Quick question.
Use the mic. Thank you.
On Hypo 13, I don't understand if there's a picture, I don't know, let's say there's a naked picture of this person. How does that affect the litigation? That has nothing to do with any compromising information for the case that's before the court. I don't understand what kind of a picture would affect this case.
It's very unclear from this hypo. That's why I was just saying you have an obligation under Rule 3.4, and you should just be aware. I don't know what the investigation is. I don't know what this give her pause is, but the idea is if it is damaging in some way and there's an anticipation that you're going to be in litigation, you shouldn't destroy it. There's nothing wrong with taking it down, but you should probably keep an eye on it. This hypo doesn't say that it's relevant, that exactly what the issue is.
Well, Judge, we did get a question on this, and that is, what was your experience with the use of social media acquired material in the litigation that was brought before you? The questioner wanted to know what were you doing or how were you managing the disclosure or any required disclosure by the parties of any social media research they did on any of the witnesses or the jurors. Have you had that? Did you have that one? No. You were trying cases? No?
No, I mean, I didn't get the discovery part because I wasn't in a motion room. The only time I saw it come up was actually Judge Washington next door came over and we talked about it. He had a case where someone said that they were injured badly, and on his social media post, it had a picture of that same person doing, half gainers off a 3-meter board. and they waited too long was probably the bottom line of it. But if you had it, I don't think it was asked for in discovery, but I think they brought it up later in the trial. So that was the only time I saw it at all.
Okay. One thing, by the way, when we've done this in the past, this polling is kind of new to us, and it's changing the dynamic of the questions that are coming in, and they're far more focused, and would encourage you, those of you who are on the computers, to maybe throw us a question as to why you voted a certain way, or give us a comment about why you voted a certain way, or ask a question that challenges the other answers that you did not, give. Okay, so Hypo 14, it's our computer. Apex Company is sued for age discrimination by one of its longtime employees. In a meeting between outside counsel and in-house counsel for Apex, the idea is offered that the employee's computer and cell phone, company issued, should be searched for any helpful information. After hours, one of the computer geeks downloads all of that information, which in-house counsel reviews the next day. He is so happy to find that the disgruntled employee has been communicating with his lawyer using the company equipment. Quote, wait until we embarrass that old guy with his candid conversations with his lawyer, end quote, the general counsel exclaims. Are there any ethical problems there, Professor?
Well, it's not good news that the general counsel is referring to the age discrimination plaintiff as that old guy, but that's probably a privileged communication. The Rule 4.4a prohibits modes of discovery that invade or violate the legal rights of the parties. So the question here is, did they violate the legal rights of the employee by examining their own computer and cell phone? So that would be a matter about that would be litigated, I think, on those terms. So did the employee get notice when he was hired, as many companies do, that any communications over the company's media are not confidential, and you shouldn't assume there are. It's not a privileged communication if the parties do not take reasonable steps to protect the privilege. So that's how this would get litigated. If there were no such notice, he could say it would be inappropriate for the company to invade his attorney-client relationship.
Jane, what's your take?
And as we talked about before, increasingly people are using their own computers, their contract employees and whatnot, so they wouldn't have that standard. You should know that your conversations on company computers are not privileged. So I think that's a very interesting thing. If you just took out the company issued in the hypo, you might get a completely different result.
But wasn't there, actually, when I read this hypo earlier today, again, it was the thing that jumped out at me that I thought you all would be talking about would be the privilege issue. That here you have an employee talking to his lawyer, the old guy's talking to his lawyer, and now, you've invaded his privacy, and it's almost like you didn't expect to get conversations between him and his lawyer, I would think. So it's almost like the employee inadvertently gave you access to privileged information. Is there a clawback issue there, or is there some obligation the GC had to disclose to the employee what they found on the computer and the cell phone?
That would be after the fact. I don't think they are going to disclose to him at the deposition, of course, the next day in a kind of most embarrassing sort of way. I don't think there would be, the real question is whether or not the initial conversation is privileged, and whether or not it violates the legal rights of the employee to find out what's in there. If it doesn't, then it's like any other discovery, and I think it would be available or required to be turned over if it was responsive to a discovery request.
I signed something that said, all of my conversations on the commission's assumed to be not confidential.
So you're saying they're see, because again, this is interesting, because I'll tell you the dynamic that's going through my mind. So, in my law firm, we have firm-issued telephones. And, what if one of my employees is in the middle of a divorce? And they're, all of a sudden, this circumstance is here. The employee's going to leave the company, and I want to, and they might make a claim against us, and I want to go search, and I find out a bunch of information, or I get emails between him and his lawyer in the divorce case, and I'm being mean, and I send those emails in his divorce case to, Miles's opponent. I mean, am I violating privilege, or are there issues there that we have to worry about?
I think would all be what are the implications of your unarticulated contract between you and your employee? Does he understand that anything that goes on that phone is fair game for you to do with it, whatever it is you want to do?
So is a lesson to be learned from this discussion that for all of us owners of law firms really need to take a look and make sure we have policies on this?
Well, that's certainly right. I mean, for the owner, I don't know how interested you are to find out everything that your employees are communicating about. Some people don't want to do that. From the employee's point of view, it suggests that you have another computer or another cell phone if you want to have confidential communication.
We have a question on the web as well.
Okay, we got a couple of them. Let's go with the lady first in-house who's got a mic in her hand.
Thank you. My question is, back to the professor's comment about is the communication privileged? And I think my question is if it's a phone and it's texting, not privileged if it's the company's phone. But then if you're talking about a computer and it's a personal email that happens to sometimes be pulled up on the computer, how do you say whether or not that is or isn't privileged or something that the company can access because it's not the company's email and it might not have been done during company hours, it just happens to be the web. It's been pulled up once on that computer, that's the company's computer, but to what extent can that information be used?
It would depend on the agreement between the employer and the employee as to the employer's access to the contents of those communications, personal or not. And the problem, of course, is that that's likely not to have been made explicit. So then it's going to be what's the implied agreement with regard to that matter, and then you're in a big legal mess.
Okay, let's take
And
the web.
regardless of the ethical
I'm
rules,
sorry.
what's the professional thing to do?
Yes.
And Steve
On the web?
on the web is asking, is interested to hear from the panel any thoughts on if the company pays a monthly stipend to the employee to the employee to utilize their personal cell phone for company business, would that change the analysis?
Make it much harder for the employer to gain access to this material.
And then Carl is asking, what about the expectation of privacy when you're on company equipment?
Again, it's the reasonable expectation of privacy. So if you have a chat with your lawyer in a crowded dining room in the middle of a deposition and there are people all around you, your subjective expectation of privacy does not protect the privilege. It's a totality of the circumstances, reasonable expectation of privacy. Same thing, I think, would apply here.
The back of the room?
Thank you. In this particular case, since you're already in litigation, couldn't you avoid the problem by putting the other side on notice that you're going to examine the equipment and give them 72 hours to go to court to get an order from the judge to block that if they can?
Well, why would we do that? No, sir.
This is a course in ethics. We're being ethical.
Okay, got it. Okay. Professor?
Very courtly of you. Yeah, that would be a kind of level of civility that many lawyers might want to embrace.
Or give them 72 hours to take stuff off the computer.
You know what? I'm being the devil's advocate here on this one. You don't have an obligation to do that. It might be nice, might be pleasant, might be, but...
Professional.
Well, what do you mean by that? What do you mean? I mean, seriously, where is the duty I have a client too. Don't I have an obligation to my client? And I'm not doing anything that's prohibited by the rules. We just agreed to that. Let's pretend to use your ARDC example where you signed a document that said you have no expectation of privacy on the company dole and equipment. I know it'd be nice to give you 72 hours. You know what's going to happen. They're going to go scrub it, right? Or do whatever they want or try to get that court order. I don't know. I'd like to debate that one a little bit more. Mr. Bierman, you have a question.
This is very troubling. Let's take another hypothetical. The employee takes this company-issued phone, and he's going through that same divorce, and he goes through it to his psychotherapist, and he records on that phone the interview with the psychotherapist. Now, that's a highly, highly privileged communication, and I think that we're missing the boat here. I don't think it should make a bit of difference who issued that phone when the fellow is talking to his lawyer or his psychotherapist, some situation where he's in a privileged communication. I think the privilege trumps all of that.
Yeah. And that goes to the gentleman in the back's idea, I think, of going in, getting a protective order or giving disclosure of some kind as a, at some point, to his point, we are members of the bar who need to have a responsibility to protect the profession and to protect the public we serve, right? And maybe those are the things that we do proactively. We have a question in the audience.
Well, again, in terms of the reasonableness, is it reasonable to assume that is it reasonable for the individual to use someone else's computer, someone else's phone, to record such sensitive information?
But you know what's, my answer to that question is yes, because I'll tell you what's happening, right? So, and I'll just take my little law firm. So I asked one of my young law students the other day, and we were looking through contacts, and I said, well, look in your Rolodex. She did not know what I was talking about. This is an absolutely true story. My point is that all of their phones are now personal to them. We have a lawyer who built a new house and does not have a hard line, and his phone is his CLO issued phone. He's using his computer. They don't have a separate Gmail account that they're using. So I think the expectation of privacy has really been ramped up to Miles's point that people are doing everything. You have one life, and it's one life in your privacy, and one life in your personal, and one life in your profession, unless we start instructing people to do things differently.
But there are two extremes here. One in which no policy has been issued, in which case you still might think, should I have this on someone else's equipment that can be recovered by someone else? It's like speaking in the crowded dining room. It's not wise. It may be, your expectation may be violated. The other extreme is what everyone should do. Anyone who works for the government, you're not to do anything on any of this equipment. People do, but they do it at their own risk, knowing that it's going to be listened to, it's not going to be privileged, the government has a right to look at it at any time. And so you have the two extremes. No policy being enunciated, and a strict no-use policy.
Well, maybe
being
that's the best
enunciated.
one. We have questions from the web. Pam?
Yes, Richard says that the NLRB held last year that employees who regularly work on their employer's computers have the right to use them for personal use so long as those purposes are useful, and which of course doesn't address the issue of privacy. But we had another person here that I'm trying to find here. Sheldon says that New Jersey goes the other way in Stuttgart versus Loving Care, that privilege survives on a computer even if the company has a policy. So I don't know, Professor, if you're familiar with that case, Stuttgart versus Loving Care. I have the site here.
Oh, well, I think moral of the story, have a policy. Professor, were you about to say something or no?
No.
Okay.
I'll pass.
Well, then I'll give you a chance here. All right, hypothetical number 15. Client direction. Mr. Smith was driving his son's friend to a school dance when he was involved in a serious automobile accident. The friend's family sues both Mr. Smith and the other driver for back injuries that the friend suffered as a result of the collision. The insurance company enters a defense for Dad and hires Caldwell and Moore, they're there again, to represent Dad in the proceedings. At the insurance company's direction, Mr. Caldwell seeks a physical examination of the plaintiff by an insurance company physician. That physician reports back that while the friend's injuries are not serious, the physician did discover an aneurysm in a very dangerous spot. Mr. Caldwell calls the insurance company to ask them what they would wish him to do with this medical report. The insurance company agent replies that the aneurysm should remain undisclosed, quote, otherwise this two-bit case will become a major liability, end quote. Wow. What should the lawyer do? Should he follow the directions of the insurance adjuster, Professor?
No.
No. Okay.
This is a famous case. This is Spalding v. Zimmerman. It was decided by the Supreme Court of Minnesota probably 25 years ago. And the Supreme Court of Minnesota, the case came up on in another procedural posture, but basically did not disapprove of the lawyer following the instruction of the insurance company, said they did nothing wrong. But they were proceeding under a version of the confidentiality rule that allowed for disclosure only to prevent a crime. Prevent a crime that would cause death or substantial bodily harm. And that didn't, so this hypothetical would not be that situation. Illinois, however, has amended its version of Rule 1.6, and the Illinois rule, unlike the model rule, is mandatory. So this is one of the few mandatory obligations under Rule 1.6, requires an Illinois lawyer to reveal information that he reasonably believes to be necessary to prevent death or substantial bodily harm. So if you believe that this information is reasonably necessary to prevent death or substantial bodily harm, regardless of its source, irrelevant as to whether or not it has to do with a future act of the client, your obligation is to reveal it. And Illinois is one of the few states that have a mandatory obligation to reveal. I think the real bite of this rule, by the way, is in the environmental context. I don't know of authority on this yet, but environmental lawyers are going to be consistently running up against situations where there's pollution that may have some percentage chance of increasing the likelihood of serious diseases by some chance within the next 5 years. Does that mean that that lawyer is obliged to reveal that information under the Illinois rule? I don't know the answer to that.
There are some questions I believe we have here in the audience. Thank you.
You know, Professor, it seems that the same concerns would arise in products liability and medical devices in drugs. Whenever litigation might bring on an investigation that reveals perhaps a different kind of problem than was considered.
So we're talking about confidential information, not privileged communications, which is probably what this is going to be. The lawyer learns through investigation that some condition exists, some product exists, some drug is out there in the world that is likely to increase by some percentage the likelihood of very serious bodily harm within over some period of time. Does that mean an Illinois lawyer is obliged to reveal that under the rule? I think it's very troubling for Illinois lawyers.
According to what you just said, the answer to that would be yes.
I think that's right.
I guess my question then, it really puts the lawyer in a box because, how does the lawyer really know? I mean, I suppose this is an extreme example, this aneurysm thing, but to the lady's point, I mean, how do I know? I get a drug report. I'm a defense lawyer, and I represent, big pharma in a case, and something crosses my desk, and it's like the insert in a drug. You're supposed to be reading all that. You're supposed to reach the conclusion that there could be harm here, and now you've got some kind of duty. It really puts a lot on the bar I mean, so what's the background about why this became mandatory?
I don't know what the Illinois deliberation is. I think this is such serious stuff that we're not, probably two steps. We're not going to just rely upon the discretion of the lawyer, and probably they were thinking, this is speculation, that it puts too much burden on the lawyer if it's not mandatory. If it's permissive, then the lawyer has to go to his client and say, I have chosen to reveal this information that's going to damage your business. Whereas if it's mandatory, the lawyer can go to his client and say, I have no choice here. My hands are tied. I know that this, whatever it is, this drug or this toxic dump is going to cause substantial bodily harm within a short period of time. The likelihood is enormously high. I have no choice. I have to. Now, you have to reveal it to the extent necessary. So if you can convince your client to take remedial actions, get the product out of circulation, but sometimes that won't do it. You've got to make what you've learned public in order to protect the public. I think it has potentially serious effects on the way many lawyers address these kinds of questions, which they do pretty often.
If you change the hypo a little bit, and one thing that comes to mind, I'm aware of a lawyer who is in the midst of a case involving the sale of a home, and that the home had some mold issues that were undisclosed. The lawyer knew about them. The lawyer found out, and no one ever did. No disclosure, no nothing. All under confidentiality, and now there are claims that people are being harmed. So you say this rule could be in play in a case like that?
Yeah, and the standard is reasonably believed. Not knows is the highest standard. That you've got to know something is true. Here, if you reasonably believe that the mold is going to increase the likelihood of cancer by, let's make it hard, 50% over the next 10 years, then you reasonably believe that that's true. It seems that this rule would require you to take action of some kind.
Jayne, I saw you looking before. Who's coming up with this rule that's making it mandatory on us here?
I was looking for a comment. There is no comment to this rule, Part C, and it strikes me that it's one thing if you have a specific person, like in the hypo or the mold situation, or a specific timeline, but neither of those is written into the rule. So I don't know. It's a very, very broad rule in the environmental situation. What if it's 20 years gestation period or whatever the half-life of the isotope could be. It's very troubling because there's no
It used to be imminent
parameters.
Imminent death or substantial bodily harm. That was changed to reasonably certain death. So the time frame doesn't appear to be crucial anymore.
Tom is asking on the internet here, if you have damaging information, do you have an obligation to disclose it, such as a general risk to the population? When do you give notice to, and how do you accomplish it?
Boy, that's so context specific. It's hard to answer that question. You would tend to go to the regulatory body that would address this kind of issue. Let them take it from there.
Right. Might not give an answer to everything today.
Sure.
Go ahead,
Can I
Your
ask
Honor.
a question?
Yes, of course.
Would this apply in criminal cases? The case where a criminal defense attorney has knowledge that, say, his client committed a murder, but another individual is charged with it?
Yeah, Massachusetts, I believe, is the only jurisdiction that has an explicit rule that allows for disclosure under those circumstances. The question is 30 years in an Illinois penitentiary, is substantial, is there a reasonable likelihood of substantial bodily harm?
I think the answer is yes.
We can pull that.
All right, moving right along here. This one here is very timely. Hypothetical 16, Facebook friends. You are preparing discovery requests regarding an employment discrimination claim brought against your Fortune 500 client by a disgruntled whistleblower who alleges a host of misdeeds in your client's public relations department. One of your junior associates reviews the boilerplate in the form you have used in these cases for years and says, quote, "If you really want to get some good stuff here," she proclaims, "you will forget sending these requests. Just friend her on Facebook and you'll find out who you are really dealing with," end quote. Any problems there? Answer, no, as long as you either have your investigator take the request or disclose you are an attorney, or B, yes, you do have a problem and you may not access the Facebook page of an adversary party, or C, you're not sure. This one we're polling. Jayne Reardon, what do you think?
Okay, so there are two types of Facebook pages. You certainly may access the public Facebook page of anyone, but if you are sending a friend request, you are trying to get at the Facebook page that the person deems only available to their friends. So there's a few ethical problems here to be considered. First, you have to be truthful. So do you really want to be a friend with this person? Probably not. You really want to get dirt on this person to find out some things that you could use in your litigation. That's a problem. Furthermore, as a lawyer under rule, so that's 4.1, you have to be truthful. 4.2, you're not allowed to communicate directly with somebody represented by counsel. So if this person has counsel, if they're an adverse party, you should not be doing it. And of course, you can't have your investigator do something that you yourself can't do under the rules. That would be a problem. There's a couple of ethics opinions in your materials. San Diego looked at this. The Bar Association there made it clear that you can't communicate with opposing party to access the restricted content on a Facebook page. And then there's a Philadelphia Bar Association ethics opinion that says friending, that act in and of itself is deceptive. And so then you could be violating rule, or be subject to Rule 8.4C for even making the friend request, because it's clear the person wants to access the page to get information to impeach the witness's testimony. In that case, the attorney was found to violate Rule 4.1, 8.4C, and because they tried to use an investigator to get at that 8.4A, which said you can't put another person up to violating the rules. So they got a triple whammy there.
Okay, Professor Burns, anything to add to that?
Just a little. It wouldn't be enough to say that you are an attorney. You'd have to tell the person that you're the attorney that represents the company with whom the person is adverse.
Judge Dooling, so let's change this up a little bit, and you got prospective jurors, and you got one of your law clerks in the back of the room, and you're saying, let's be friends. Can you do that? No. The investigator or law clerk for a party is trying to investigate a juror. Can you do those things? No. Can't do that. We've heard of that. Yes.
The jurors are told,
Reardon got caught, by the way. That's bless you.
but most of the jurors, I'll tell you this, they will tell the sheriff, and the sheriff will tell the judge, guess what just happened?
Got a new friend. There you go. All right, so, okay, now there was a poll on that, and we had, 19% of the people said that there was no problem having the investigator or the attorney disclose. 48% definitely thought there was, may not access the Facebook page, and then 32% said they weren't sure. So there we go. Okay, hypothetical 17, no poll here, deleted emails. You are conducting electronic discovery. Both sides have agreed on the keywords to be searched. That production was made 2 weeks ago. Today, one of your client's key employees darkened your door and announced that he accidentally deleted a large group of emails from his hard drive before production was made. but after a careful review of what happened, it turns out that in your view, the emails were not relevant. Any ethical problems here, Professor?
It depends on how careful your review was. If your conclusion was that those deleted emails were not relevant in the discovery sense, that is, they are unlikely to lead to admissible evidence, such that you would not even have to log them in a discovery log, so they would not have been responsive to the request, I'm not sure that you have any obligation. So the rule that controls prohibiting interfering with discovery requests refers to matters of potential evidentiary basis. So you would have to be you'd have to be pure of heart in this, making this decision that these deleted emails really would not have been discoverable, and you could have withheld them and not even logged them in a discovery log because they're so unaccessible, I think.
Judge, what's your take?
I agree. I mean, unless the agreement was anything that has these keywords and
Right.
you got to turn over, then obviously the judge has got to do the review of what's relevant and not relevant. But if it's general and you look at it.
Yeah, and I think you just said something very important, and that is that you had search terms. The search terms would have caught these documents, but that's only step one of the review process. Then it becomes within the matters of relevancy. So if you had not produced them in any event, is it sort of like a no harm, no foul situation here? A little bit.
I mean, yeah, if they're not relevant, they're not relevant for any reason, then you don't have to turn them over. But if you think, if for some reason you look at it and you're,
All right.
close it and have the judge.
All right, we've got a question from the floor here. Well, if they weren't relevant, they weren't probative, maybe they just shouldn't have been produced in the first instance. So the comment was if the keywords hit, that might be enough. And maybe the safe action then, if they hit the keywords, put them on a log, fess up to your opponent in the court, and let the court do an in-camera review of them, if that's what's...
Yeah, I think the hypothetical is a little ambiguous as to whether or not what the careful review turned up. Did it turn up that these emails did have those search terms in them, or that they were just completely unresponsive?
Did I miss a question here? I hope not. Okay.
We have one actually just back to the Facebook issue, and that is on the previous hypothetical, and that is, what if the opposing party wants to friend you?
What if the opposing party wanted to friend you?
Wants to friend you on Facebook?
Answer is no.
What do you do?
No.
Don't accept the request.
All right, so we got two more hypotheticals, so let's see if we can get through them. They both have polling. Hypo number 18, loyal law firms. Our corporate client, Apex, calls Caldwell & Moore to represent the corporation and 3 of its officers, but wants to make sure if a conflict develops that Caldwell & Moore will continue to represent the corporation. We had a little bit of this earlier. You assure Apex that the firm will take on the representation of both of the corporation and all 3 officers, provided the parties consent and sign a waiver agreeing that if a conflict later develops, Caldwell & Moore will withdraw from representing the individuals, but will continue representing Apex. Is there an ethical problem there? Jayne, what's your take on that?
Yeah, we kind of covered a little bit of this earlier. The applicable rule is Rule .17. The issue would representing the corporation and 3 of its officers put you in a conflict. Would any one of them be adverse to each other or to the corporation? And then can this, it's very, very unclear whether the condition in B3 of Rule 1.7 could be met, and that is the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation. So it's probably the wisest thing not to do it, but then the question is, can a client consent to withdraw later if a conflict develops. And that's a problematic thing as well.
They might need a counsel to advise on that issue. What's the poll say? Survey says, hey, yes, 68% say, is there an ethical problem here? Yes, 32% say no. Okay, onward to our last hypothetical. We're right on time. The conscientious GC, Colossus Corporation, is being investigated for possible SEC violations. The SEC starts administrative proceedings against the CEO and the director of the research. Each is subpoenaed for a deposition, and the GC tells the two individuals, I will go with you. Those depositions are taken. Thereafter, the company decides to waive the privilege and permit the deposition of the GC. Asked about his conversations with the CEO and director of research prior to the testimony, the GC testifies to all, explaining to the SEC that Colossus has decided to waive the privilege and that she always suspected those two employees were up to no good. Any ethical issues there? So, Professor, what do you think?
Yeah, I think you got some problems here. I mean, the initial problem is, I will go with you to the deposition, could give rise to a reasonable inference that he was offering representation of the individuals at the deposition. You can do that under 1.13, but you've got to have it can't be any conflicts under 1.7. Here, the lawyer is saying, I always suspected that these employees were up to no good. So at the moment when she would have been offering to represent them in the deposition, she already harbored suspicions that there was adversity between the individuals and her clear client, the corporation. So first, she probably did let them conclude that she was their lawyer. Second, she shouldn't have offered to represent them because she already thought there was adversity between them and the corporation. And then the problem is if they do reasonably conclude that she was their lawyer, they have a privilege as well as the corporation privilege, and the corporation can't waive that privilege.
Jane, anything further?
Nothing further.
Well, listen,
We
folks,
have some
we have a question, I
another
think.
question
Yep.
here just in the last minute, and that goes to that hypothetical again that was so active on the cell phone use and in the employer-employee. And several people were asking, including Rochelle, what if the employer is a public employee, a public employer? Does that make a difference if the employer is a governmental employer? With the cell phone.
Well, that might go to that gentleman's comment before about governmental employees and just having a hard rule and all of that. I think that's an answer there. Well, listen, ladies and gentlemen, we are finished. I am grateful to our panel. Thank you so very much. Thankful to everyone here live at DePaul University, great law school, and thank you to everyone who is on the internet with us today. We'll see you next year.
Yes, and thank you for attending today's program, The Changing Ethical Landscape of Litigation. Please be sure to fill out and submit the evaluation form that can be found by clicking on the evaluation tab. Certificates of attendance will be emailed within the next week. For those of you here attending in person at DePaul, please be sure to pick up your certificate of attendance just outside this room. And please take a moment to fill out the evaluation form that was at your seat. On behalf of all of us here at Clifford Law Offices, we thank you for attending and look forward to seeing you again in the future for our future programs. Good night.
Good night.